which never knew existed.
All right. Good evening, ladies and gentlemen. Kind of coming on tonight for a little bit of an impromptu stream. I did not do either date night nor the week in review this weekend. Some of you guys caught it. I said it on Thursday. I said it again on Friday on Badlands Daily that I had to travel this weekend. My stepdad was not doing so well, and he was in the hospital, and had to go up there and see him, and then also kill two birds with one stone and be with my mom for Mother's Day, which was awesome. Spent it in the hospital with my stepdad, but that's great because we were all together, my wife and I, my mom, and my stepdad. Again, he's been my stepdad for almost 30 years. So, you know, he's extremely, extremely important to me. So had to go up there right away to see him. He's fine. He is going to be having surgery, back surgery. And he had some complications from that where he was not able to move and he fell. And, you know, he's getting up there in years a little bit. So he's in the hospital now. I bought him a Fire Stick, so he could be watching, possibly. I'm not sure. But if he is, get better, and I'll see you soon. We'll come back up soon and see you again. But there's been a lot going on over this week, and I felt like I really needed to come on here and talk about some of the things. It's a lot election related. We had the Louisiana decision. We had the Virginia Supreme Court decision. We had the Fulton County, two things happening in the Georgia cases. Wisconsin's popping up on the map. You know, we've had the redistricting in Tennessee. There's just been so much over the last week. It's a lot to take in, and there's some things that I got to talk about here because there's been some situations where we've been out in front. Me and Ash and those of us at Badlands and so many others have been out in front on a lot of this. There's a lot of vindication coming about. We're kind of starting to see, you know, some hints that something might be coming out in the coming weeks. So let's jump right into it. And I want to start out with the Virginia case. This is something that, you know, when I saw this decision, when I saw the ballot referendum on April 21st, I was live with Ghost of Base Patrick Henry on Badlands Daily. It was Tuesday, April 21st, the day of the election. And Ghost had gone to vote that morning. And so when he came on Daily, he drops on me, yeah, we had a ballot referendum and I voted, and, you know, it was like, you know, to like restore fairness. And I was blown away. I was like, whoa, wait. So the ballot actually says to restore fairness? Yes. Do you want to redraw the maps to restore fairness in the Virginia election primary process, whatever the case, or election process, whatever it was? And I was like, holy crap, that there's no way that a ballot initiative to amend the Constitution could ever say that. So I'm not going to rehash that whole story. As soon as I started digging into that case, I looked at some of the past case law. I read the Tazewell decisions from Judge Hurley. There were two cases that were brought in 2025, October 2025, and then one a little bit later on. And I wrote an article for the Gateway Pundit, outlined all of the different cases, the arguments that were being made, so to speak. You can see that article here. I wrote that on April 22nd, titled "Restore Fairness: The Ballot Battle for Virginia's Maps can continue in the Virginia Supreme Court." I outlined all of the different violations that were alleged, or that were ruled on. I shouldn't say alleged; they were ruled on by the Tazewell County Circuit Court. And basically, this all boiled down to a few things. One, they went about the process unconstitutionally to amend the Constitution. That was first and foremost. The second big thing about this was they changed the verbiage. The third big thing was they didn't all post the amendment, proposal to the clerk of the courts and in each circuit. That's one of the requirements. Now, again, when they did this, when they argued this before the Supreme Court during that hearing on, I think it was like April 20, maybe 8th, I think it was the Monday after. So maybe the 27th when they argued before the Virginia Supreme Court, the court basically agreed, yeah, that's kind of a nullity now, right? You don't need to do that because we all get our news from social media, et cetera, right? The other thing that they went on to talk about was the bill that they used to put this on the election, the bill that they used to fund this election for this referendum. And that is kind of what I want to focus on here, because I got a lot of flack. So this weekend I put out this post right here, and I'm sharing a post from Adam Parkhomenko, who says the best argument regarding the Virginia decision that I've heard is this. And he's responding to Julian Sanchez on Blue Sky that says, this is particularly maddening because the court allowed the election to go ahead when all the legal facts were exactly the same. The only real new information that we have now, that they have now, is what the result was. So again, I got a lot of flack from this because I posted that we called this. I've been saying this since day one, that not only is this election going to be overturned, but that the Virginia Supreme Court failed by not ruling on it. And everybody's like, oh, you're a Democrat and blah, blah, blah. I'm like, guys, there's an icon in my handle for the Gateway Pundit. You think I'm a Democrat? Just click on my link in the background image on my profile. This is how many bots there are on X, by the way. And this is a bot-heavy subject. Like, there are a ton of bots engaging right now on this Virginia Supreme Court subject. Okay. Now, you guys got to take the partisan stuff out of your eyes for just a minute here. We got to talk about this strictly from the legal aspect of this case. I understand that the Democrats argued that the Supreme Court has to let the election take place. I understand that. I understand that Scott v. James is precedent saying that the election needs to have taken place. And we're going to get into that. And I'm going to explain to you why that precedent should have been overturned. Okay? Galactic Gaming Den says, been hearing the Democrats in Virginia want to pass an executive order to lower the age for the Supreme Court. Yes, I'm seeing this as well, to 54 so that they can replace all of them and then retroactively overrule, the ruling that came out, overturn that ruling. Yeah, I saw that too. Do they really want to go that nuclear? I mean, at that point, you better nuke the filibuster. You better nuke the filibuster, and you better cram through as much law as you can, because if they're going to change the law in Virginia to get Supreme Court justices in order to gerrymander that state, then all hell is broke loose. And that is, for all intents and purposes, that's a declaration of war at that point. If you're willing to change the laws in order to gerrymander a map, and then retroactively overturn a Supreme Court decision that is clear as day in violation of the Constitution. Now, is that going to happen? I highly, highly doubt that. But yes, you are correct. I've heard that argument out there as well. So, again, the post that I put up, I've said this multiple times after the referendum vote, the Virginia Supreme Court royally messed this up, and I still believe that. And I've argued, there's, I think, like 143 comments, and I've responded to almost all of them, standing my ground on this. They had plenty of time to rule on the merits of the Tazewell decision. They punted, and they caused this chaos. Now, fortunately, we did not see the chaos that I thought was going to ensue after this decision. I thought there was going to be a lot of chaos. I thought they were going to be in the streets, but there may be a reason for that. And we'll go over that here in just a second. But I do want to pull something up real quick because, in doing this, I went and I looked at, some of the precedent that they're talking about here, specifically the Scott v. James case. And I want to go over here. Let me get this pulled up because I was not prepared to pull this this article in as well. So, okay, I got that pulled up. So let's go ahead and jump first and foremost into the Virginia court ruling. And we're not going to go too heavy on this because the ruling is correct, okay? And I want to be clear with that because a lot of people were like, oh, you don't know what you're talking about, and the ruling and blah, blah, blah. The ruling is correct. The timing is not. And I'll explain to you why I believe this here in just a second. Let me get the chat pulled up on the side here so that I don't have to keep switching. The one bad thing about OBS Studio as opposed to StreamYard is it's difficult for me. So I want to be able to keep tabs on the chat with it. So if I switch over to see what the chat's saying, it looks like this, and I take away the screen that I'm trying to share. So with OBS, I don't do that. So, okay. So the relevant part here of the decision, the ruling that came down on May 8th, Friday, is on page 7B right here. It says, it is fair to ask whether we could have or should have reviewed the constitutionality of the proposed amendment prior to it being presented to the voters. But it is not a question the Commonwealth should ask. Throughout this litigation, the Commonwealth has insisted that we cannot lawfully decide this case prior to the referendum. In its motion for a stay in this case, the Commonwealth argued that long-standing Virginia precedent, Scott v. James, from 1912, by the way, was, quote, virtually indistinguishable, end quote, from this case, and that it clearly held that, quote, courts cannot interfere to stop any of the proceedings while this permanent law is in the process of being made. And also, quote, only upon the completion of the proceedings, if the validity of the amendment is assailed on the ground that the several provisions of the Constitution have not been complied with, then the courts can pass upon the validity of the amendment. Okay? Now, again, I want to reemphasize this. Just because they argued that they can't do this doesn't mean the court has to. And that's the excuse that everybody's been giving me. The Democrats argued for this and they got what they wanted. The courts gave them what they wanted. That's not the court's job. You cannot find a single litigation out there where the appellants argue against their own case. You know, they argue that the court should not rule against them. That's the whole point in having the controversy, right? The case and controversy clause of Article 3 of the Constitution, that every case brought before the court is essentially either a case brought or a controversy brought before the court. And you're going to have litigants on both sides arguing. You're not going to see a litigant be like, well, you know what? We're here to argue this, but you know what? Just let those guys win. Just let those guys win. And so that's really a dumb point. Anybody that's saying, well, the Democrats argued this and the courts and they made the courts do this. No. The courts hear the arguments and then they decide. Okay, that's how it works. So let's keep reading here. It says, the Commonwealth concluded that, quote, the lesson is clear. Courts may not preemptively invalidate a proposed constitutional amendment before it has been passed by the voters, end quote. Goes on to say, Scott makes clear that the process, the quote-unquote process of amending the Constitution is not complete until the voters approve or reject the amendment, end quote. Having successfully insisted over the objection of the claimants that we postpone judicial review of the constitutional amendment until after the election process, it might be tempting for the Commonwealth to think that the final vote implicitly stacks the deck in its favor. Perhaps enough so that the exercise of any judicial review could be viewed as an ultra-vires effort to overturn the will of the people. That's exactly what they were hoping for. So in Scott v. James, I'll give you just a little background. And there's an article, Cardinal News has an article up about it that we'll get into here in a second. But a little background on Scott v. James. It's a 1912 case. It originated from the 1910 or 1910, they began to try and amend the Constitution. The Constitution in Virginia was amended or rewritten essentially in the post-Reconstruction era. The Virginia Constitution was essentially redone in 1902. Now, the craziest part about them redoing the Constitution in 1902 is that they never brought it to a vote amongst the people. The legislature just basically said, here's the new Constitution, just enact it. Just enact it. The people have no say in this. And so there's a lot of questionable things in that Constitution, and Virginia would go on to basically dump their Constitution, start all over again a couple more times, most recently in 1971. And so the Constitution that was in question, the amendment, it's remained mostly the same. They changed, I think, the term of election for, you know, the election that intervenes between the votes of the House of Delegates. They changed the verbiage of that a little bit. I think it used to be something along the lines of the choosing of the delegates, and now it's the general election, the next general election. I think originally it was the next choosing of the delegates, but now it's the next general election, and that's kind of the grounds that we find with Scott v. McDougal, which is the case at here. Scott v. James is the precedent. Scott v. McDougal is the case that was argued here. Okay. So again, having successfully insisted that we postpone judicial review of the amendment until after the election process, it might be tempting for the Commonwealth to think that the final vote implicitly stacks the deck in its favor, meaning that because they said yes, we got to vote with the people. We can't overturn this election, and that was their intention. Make no question about it. Make no question about it. And that actually adds fodder to the. That adds tinder, I should say, to the argument that I'm going to make here about why they should have overturned Scott v. James. Perhaps enough so that the exercise of any judicial review could be viewed as an ultra-vires effort to overturn the will of the people. If this supposition were true, that Scott forbids pre-election challenges and that the free will of the people forbids post-election challenges, then judicial review of allegedly unconstitutional procedure used to adopt a constitutional amendment would not exist in the Commonwealth of Virginia. So again, if this supposition were true, that Scott forbids pre-election challenges and that the will of the people forbids post-election challenges, then judicial review of allegedly unconstitutional procedures it doesn't exist. So in other words, they're saying, well, if we can't look at it before the people vote and we can't look at it after the people vote, then there is no challenge to the Constitution. They can do whatever they want. Now, again, I want to go back and I'll show you why the latter, after the people vote, is actually detrimental to the people. There's injury caused to the people by doing that. And I'm not talking about overturning the will of the people, but we'll get to that. On the issue before us in the case, we hold that the ultimate vote margin plays no role in the analytics of our judicial review of the constitutionality of the pre-election constitutional amendment process. Neither a high margin of success nor a single-digit margin, supra at 5, logically or legally matters. As we explained earlier, it cannot be overstated. This is a quote. It cannot be overstated that Scott focused only on the timing of the exercise of judicial injunctive remedies, not on a court's constitutional power of just judicial review. To be sure, Scott emphasized that, quote, the Judiciary Department has the power and it is its duty to pass upon the validity of a constitutional enactment when put in force, as well as upon the validity of an act of the legislature regularly passed and put in effect. If the electorate rejects the proposed amendment, any pending legal proceedings will be dismissed as moot. If the electorate approves the proposed amendment, we then must exercise our constitutional duty to review lower courts' declaratory judgments before us on appeal and address de novo what equitable remedies, if any, are appropriate. Article 12, Section 1 of the Constitution mandates a detailed process governing the lawful adoption of constitutional amendments. These procedural requirements may seem laborious to some, perhaps even painstakingly so. The ambition of a constitution, James Madison said, is to create, quote, a government for perpetuity, end quote, grounded by, quote, permanent principles and not on those of temporary nature, end quote. Debates of the Virginia Convention, 1788, reprinted in the 10th Documentary History of Ratification of the Constitution, 1184. For this reason, the Constitution, quote, necessitates compliance with the requirements of a deliberately lengthy, precise, and balanced procedure. Quote, strict compliance with these mandatory provisions is required in order that all proposed constitutional amendments shall receive the deliberate consideration and careful scrutiny that they deserve. I'm trying to read until I get to the point where they talk about the arguments. Stand by 1 second. To guard against any Hold on. They argue in here. Hold on. They argue that the outcome would not. All right. I guess they're not going to Okay, I'll just explain this part to you because I can't find it real quick. But during the oral arguments, which we listened to on here, right? We played the oral arguments and we listened to them. I've clipped them out. You guys can find all of the clips and everything on my X. Ash and I talked about it on Why We Vote. But during the arguments, the appellants, which means the Commonwealth, the quote-unquote Democrats, for lack of a better term in this, they argued to the justices that, yeah, well, you have to wait until after the election, but the outcome of the vote does not affect this case, right? It doesn't affect this. And the justices, of course, agreed. It could have been 75-25, yes, and that still should not weigh on the justices about the validity of the procedure by which they passed the amendment. And so here's my problem, and this is where I think that well, you know what? Let's get into the history. Let's get into the history of James first. Okay, so this is from Cardinal News. This was March 12th, 2026. So this was before, a week after the election. Why the redistricting results might not stand, it's because of a Lynchburg man who wanted to run for office more than a century ago but never did. And they're talking, of course, about this man. He goes by the name Colonel. That was a nickname given to him by Claude Swanson, the governor of Virginia at the time. And so let's jump down here. So basically, this guy, Scott, they tried to amend the Constitution in 1910 to allow for the city treasurer and the city commissioners to have extended terms. So normally they would term out after 3 terms. They wanted to extend it, okay? And in order to extend it, they tried to amend the Constitution. And the first General Assembly passed it, and they had the same procedure. The first General Assembly passed 2 amendments, one for the treasurer, one for the commissioners. And they both passed. The election took place. The next one comes. They both pass again. Then they take it to the vote of the people. But when they brought it to vote for the people, instead of having 2 different referendums for 2 different amendments for the treasurer and the city commissioner, they combined them. Okay. And when they combined them, the people rejected it. It failed. It did not pass vote. And so that was the 1912 period or 1910 period. I think it might have been 1908. It was on the 1912 ballot. So then what they tried to do is they tried to turn around again and do the same process. They put it right back on the ballot. They didn't go through the process again. They put it right back on the ballot by breaking the referendums up this time. And that is where Scott sued. Scott sued in that process and said, hey, I'm trying to run, but this guy's supposed to be termed out. Henry Adams, I think, was the guy's name. And they said, I'm trying to run out. James, I think, was the attorney general at the time. And that's why it's Scott v. James, I believe. I could be butchering this. The names and everything. Let me see. Virginia lawyers who deal with election law know the name Scott versus James as the suit is officially styled. However, I couldn't find any actual blah. We begin in 1900. That's when Henry Adams became treasurer in Lynchburg. So I was right about Henry Adams. At the time, Virginia was operating under the Reconstruction era state constitution adopted in the aftermath of the Civil War. The Constitution, drafted by a biracial assembly in 1867, was considered quite progressive for its day. It required public schools and mandated attendance. It expanded the electorate to include all men, black and white, and instituted the secret ballot. The end of the Civil War saw a brief era in which racial harmony, if not actual equality, seemed possible. The era quickly faded as white supremacists came to power in the 1880s and instituted what we know today as Jim Crow laws of segregation. There was just one problem, as they saw it: the Reconstruction era Constitution that allowed black men to vote. The solution was a wholesale rewrite of the state constitution for the express purpose of denying as many black men as possible the right to vote. In 1902, a state convention drew up a new constitution, and rather than put it to a vote where it might fail, the convention simply declared the new document was in force. The 1902 Constitution eliminated about 60% of the state's voters, not just black voters, but also many white voters in Southwest Virginia who had historically voted, quote unquote, the wrong way in the eyes of conservative Democrats who ran the state. That's a story for another day. What matters is that in 1902, Virginia got a new state constitution, and for its provision, limited treasure, and one of its provisions limited treasurers and commissioners of the revenue to 2 terms. That means that Adams' days in the city as city treasurer in Lynchburg were numbered, so were a lot of other treasurers. Political pressure built to change that. Under the rules at the time, which are still in effect today, the General Assembly had to pass a proposed amendment twice with an election in between. We've talked about that a lot here, before it could go to voters for final approval. In 1908, the legislature passed the 2 amendments, one allowing treasurers to run again, the other allowing commissioners of the revenue to do so. The General Assembly came back in 1910 and passed the amendments again, this time for reasons that I've been unable to determine, deciding the 2 amendments should be combined into a single question on the ballot. So they put them together, and the voters said no. In 1910, Virginians voted down that amendment. Adams would have to leave office once his term ended after the 1913 election, and Scott started plotting his move. Quote, it has been reported on the streets for some time that Mr. Scott would be a candidate for the treasurership of Lynchburg. The Lynchburg paper would later report. The political pressure that had prompted the General Assembly to pass the re-election amendments in 1908 and 1910 did not abate, though. With the deadline approaching, it only intensified, according to the newspaper accounts at the time. In 1912, the legislature did something legally questionable. It passed the re-election amendment again, this time as 2 separate measures, which it probably should have done in 1910, and cited the original 1908 vote as the first required vote. So this isn't the same as the case that's before us here, Scott versus McDougal. It's not the same. This is twice trying to pass it. They already failed the first time. You got to start the process completely, entirely all over again. So it's different on its face. There's some controversy about this legislature. The Alexandria Gazette reported that the measure, quote, was fought in the state Senate, but passed. Governor William Mann let the enabling legislation become law without his signature, often a sign that a governor has reservations about a bill, but is not inclined to stop it. That triggered a referendum vote in November 1912, in Scott's lawsuit. He wanted the election halted on the grounds that the amendment had been improperly adopted by the General Assembly, that the James in Scott James was the B.O. James, the Secretary of the Commonwealth, the office that handled paperwork for the elections. The suit was filed in Richmond. Scott was spotted in Richmond, but didn't want to comment on his potential candidacy. Okay. When Scott's suit came to trial that April, Circuit Judge Beverly T. Crump was skeptical. The Alexandria Gazette reported that Crump, quote, held that to grant the relief prayed for would be to interfere on the part of the Judiciary Department with the process of legislation. He further ruled that the effect of the injury would be to enjoin the holding of the election. Scott appealed. With no intermediate court in those days, his appeal went straight to the Virginia Supreme Court. The case was statewide news, where the plaintiff was typically referred to by his honorary military title. The Ledger-Star in Norfolk headlined, "Appeal of Colonel James A. Scott for Richmond Court's decision is granted." The state constitution at the time required the Virginia Supreme Court to meet regularly at 3 locations, apparently a concession to Western lawyers. The court was meeting in Whiteville in June when it agreed to hear Scott's appeal. The case itself was heard that September in Staunton. With no early voting in those days, that was sufficient time to halt the election if that was what the court's decision. Scott's lawyer from the Lynchburg firm, Harper and Goodman, argued that as a taxpayer, he had a right to challenge the state from going to the expense of holding an election that was potentially unconstitutional. The Attorney General at the time, Samuel Williams, spoke for the state, although it's unclear whether Williams himself appeared in court. Multiple private attorneys are listed in the court filings as part of the state's legal team. The Supreme Court, in its eventual opinion, noted that the case, quote, has been ably and exhaustively argued by both sides. It then ruled against Scott if the justices gave a reason why that was not reported at the time, although the Richmond Times-Dispatch said a formal opinion would follow later. The election went on as scheduled. That was a presidential election year, an exciting one. The Republican incumbent, Howard Taft, had seen his popularity plummet. That's when he went against Roosevelt and Woodrow Wilson. Woodrow Wilson ends up winning and completely and totally reshapes the entire country as we know it. Then the Treasurer amendments somehow, remember, when they were put together, they failed. They got voted down. But when they separated them, they passed 75 to 25, both of them. 74-26 and 75-25, both of them. So when you separated them, they got 3/4 support, but when they were together, they didn't even get a simple majority. That was kind of strange. And so that's the case right there, where they basically say that you have to wait until after the election. Now, again, if you look at it, does sound like John D. Rockefeller, green ozone, and that's the concerning thing to me. I think there's a there, like there's something going on with that, given the time frame of this 1912. Again, very shaky time, tumultuous time for our country. The 16th and 17th Amendments get passed. The creature from Jekyll Island, the Federal Reserve. The Titanic sinks with very peculiar passengers that decided not to attend or to sail. A lot of shaky shit. William Woodrow Wilson gets kind of pushed over the finish line. Teddy Roosevelt would end up, kind of playing the spoiler to that election between Taft, Wilson, and Roosevelt. He kind of ruins Taft's chance at winning. Yeah, it was very weird. Woodrow Wilson ends up winning that election with 42% of the vote. It's the first time. I don't think there's ever been another time in modern history, the 1900s on, where a president has won with less than 50% of the vote. And definitely not 42%. It's the lowest. But anyways, so going back to why I think that the Virginia Supreme Court should have heard the case. And again, this goes back to our law. And look, I'm not a lawyer. And that's probably a good thing, because our law is meant to be for the layman, right? You're supposed to be able to, and I can't remember. I know it was, I think it was Alan Dershowitz that said this at Mar-a-Lago when I was there, but he said that the law is supposed to be one of our founding fathers. And I think he credited it with to Madison, but he says that the law is meant to be read by the laymen while jogging, meaning that you should be able to interpret the law as a common man. It should be very easy for you to understand. Now, the argument that the Supreme Court could not rule, the Tazewell Court twice said that this was done, the procedures were violated. And there's steps in the procedure, right? And every step has a different party that's attached to it. So the first step is the General Assembly. They got to propose it. They got to pass it. Then the next step is the people. There has to be that intervening election where they vote, knowing full well they should know full well how their delegate voted for the proposed amendment. Then the next step after that is the next General Assembly. After the people get to hold accountability, the next General Assembly also has to vote and pass this. Then the judiciary gets involved, because you have to pin the proposed amendment to the court doors for 90 days, to the doors of the courts for 90 days, so that people can come by and read it. And granted, I understand that's kind of it's obsolete at this point with social media and the newspapers and TV and everything else. But you get it's still in there. And if you want to get rid of it, you got to change the law. You got to go in there and amend the Constitution, get it out of there, whatever the case might be. The courts kind of gaffed it off on this one, which is a shame, but they did. Okay, and I can understand it, but I don't agree with it, which is kind of contradictory here, because you're gonna ignore the law itself, and you're gonna be like, well, we get our news from social media, so that law, we can kind of ignore it. But then you're gonna be like, oh, this precedent, which precedent is not law, stare decisis. Precedent is just meant to is it stare or stare? Stare decisis. You're just supposed to kind of take it as a nudging in this direction. It's a suggestion. It's a very high regard, but it's a suggestion. And so on one hand, they're like, the law, we can kind of ignore that because everything's changed. But hey, this precedent right here, we can't touch that. We can't touch that. It's crazy. That's crazy. So when they go through this process, right, when the legislature is going through this process, they have two roles: propose the amendment and then to pass it twice. And then they eventually are going to pass a bill to fund the election. Once they're done with their process should be scrutinized. It should be subject to scrutiny, because there's no point in going through all of the steps when the first step is invalid and nullifies everything. And they even argued this. They said, the justices said, so if the General Assembly didn't do this properly. The vote means nothing, correct? Correct. The vote means nothing. But yet we still have to do the vote. That's so stupid. And here's why. And they allude to it in Scott. This was the basis of Scott. You are injuring the people by doing this. Especially today. You want to talk about you don't have to post it because we all have social media and we all get the news from there now, so that law is kind of null and void. Well, how about this? The election thing, the election component, having to go through the election should be null and void before you're allowed. And this is precedent, not law. So you're overturning law because you feel one way. Because as a justice, you're saying, well, we get our news from social media. But you're going to say the precedent says we have to hold this election, even if we know that they didn't follow the Constitution, the procedures were not followed. We still have to hold the Constitution. We still have to hold the election before we can, rule on the constitutional amendment itself and the procedural grounds. That's absurd. Because now when you hold that election, and again, going back 1912 versus 2026, the cost of election is infinitely more. We've got machines that have to be logic and accuracy tested. We have machines that have to be deployed. We have ballots that have to be printed and mailed out. We have election workers and poll workers all across the state that have to be. You're talking millions of dollars that have now been burdened on the taxpayer for something that no matter what the outcome was going to be nullified, most likely. I mean, anybody with half a brain could look at that and say that the constitutional, the procedures outlined in the Constitution were not followed. So you have now inflicted serious injury by burdening the taxpayer with the cost of an election. And not only that, you've also now cost, campaign donors. And, fortunately, and I called this, by the way, Republicans didn't spend a whole lot on this because I think they knew all along that this was not going to stand up to scrutiny. And, a lot of people came out when this vote first came down. They're like, oh, Trump only spent, I think, like $10 million from his PAC on this. Democrats spent like $50 or $60 million. Trump only spent $10 million. Why? And I said, because Trump knew that this was not going anywhere. Trump knew that this was not going to pass muster. It shouldn't have ever gotten to the point of an election in the first place. But so now and again, I understand the point that people are making. Oh, I'm glad Democrats spent all that money. Me too. I'm glad. This punched them right in the face because they argued that we have to let this play out. We have to let the people vote, hoping that the Supreme Court justices in Virginia would be like, oh, well, we can't overturn the will of the people. And I even said last Wednesday on Badlands Daily, I said, maybe I'm 50-50 on this because that is a tough obstacle for the Supreme Court to overcome, overturning the will of the people. And that's why the Democrats want to do this. And that's why the Supreme Court should have ruled on this right away. When they completed their action, right? The legislature's job, propose it, pass it, propose and pass it, intervening election, propose and pass it again, pin it to the court, give it to the people in an election, pass a bill to fund the election. When they were done with the two proposals and the two passages, their job is finished. Their job should be subject to scrutiny before it can proceed on to the next job if a claim is heard. And it was heard at the Tazewell County Circuit Court. And it was ruled that they did not follow the procedural grounds. So they, of course, appealed this, saying you can't do this until the end. And it did. The election is defined as just the day after, or the moment that the votes are all in and counted and all that. We talked about those ad nauseum. And so my point here, and this is why law in this country is now so retarded. I don't know how else to say it. It is so dumb that the people have to vote on this before we can rule on it. But the people's vote means jack shit because we all know that they didn't follow the rules on numerous ways, by the way. Everybody's focused on that intervening election. Well, they changed the verbiage of the bill. The House bill that they used to fund the election was numerous bills. And in Virginia, it's constitutional law that you can only have one item per bill. And they had like 6. They didn't post it to the courts, which the judge was like, oh, the justices were like, we can overlook that. It's only law. It's only in the Constitution that this has to be done. We can overlook that. But Scott v. James, that precedent right there, we can't overlook that. Even though, I mean, Loper Bright overturned Chevron, Dobbs overturned Roe v. Wade, even the Clay had precedent that was overturned in that case, Louisiana Clay case. Precedent is meant to be overturned when situations have changed so drastically. And they have. From 1912 to here. First off, we're on the third Virginia Constitution since 1912. The 1912 Constitution, the 1902 Constitution, but the 1912 Constitution was just thrown at the people. They had no say in it whatsoever. They didn't vote on it to implement that new 1902 Constitution. They've had three since then, including the 1971 Constitution, where it's so absurd to me. And again, I'm not mad that the Democrats had to spend all that money and that they lost, but I said this when it happened. I said this is a win-win for the Democrats because now they're out there saying that the Virginia Supreme Court, the Republicans, MAGA, Trump, all these people, they subverted the will of the people by overturning this election. It's like, no. They said this back in October 2025. The courts failed you by not having a hearing on the procedures that were taken. When the Supreme Court finished when the legislature finished their procedures, they should have looked at that. They should have looked at that and said, hey guys, we can't go to election. You didn't do this properly. The election would be null and void. Even if it was successful for you, it would be null and void. Instead, they let it go on. They cost the taxpayer millions of dollars. They cost millions of dollars in donors, donors that, I mean, in a tough economy where we're trying to rub two nickels together, people donated, $5, $10. You had people donating $100, whatever, because they're like, oh, I got to keep my representation. I want 6-5 representation because I'm a Republican and I want some representation. So I'm going to put a lot of money into this to try and fight it. And it was all for nothing. It was for nil. So I don't know how people don't see that. And I know that people want to root for their side because tribalism has become the Bears versus the Packers in this country, and it's Democrat versus Republican no matter what. And if it sucks for the Democrats, then it's great for the Republicans. And I'm going to root for it even if it just makes no sense. That's a very dangerous place that we're at right there. So I'm going to stand by it. I'll wrap this segment up. I went way too long on this. I'll wrap this up there. I think that the Supreme Court in Virginia should have went against Scott v. James, and they should have stopped that election. They should have heard it back in March when they lifted the injunction on the election, because the election was enjoined in March. In March, they lifted the TRO, the temporary restraining order, to conduct the election. They enabled the election to go forward. They didn't. It's not like they said, yeah, we have to let it go forward. They said, it's not going forward right now because of the Tazewell court. We're going to lift that injunction and make it go forward. That's where the problem comes in for me. And again, I can't. I know the guy whose post I was sharing. I mean, check this out. The guy whose post I'm sharing right here. He is a Democrat strategist, former DNC national field director, and a Hillary Clinton advisor. And I even said he shares my post and says this is correct. I wrote here, I made that argument on April 21st. Partisan politics aside, the Virginia Supreme Court screwed up by not ruling on the merits when they had the chance. It was a no-brainer. Our dependence on precedent is so messed up. And he responds to me. I think he says, he said something along the lines of, we don't agree politically on issues, but it's good to see you on this one. So, okay, let's land that there. Let's take a second and just pop in the chat real quick and see what's going on. The rest of the show won't be too long from here. I'll get you guys out just about, not just about in time for narrative, but Burning Bright, he likes to talk a lot in the beginning, so we'll raid you guys over there. So there we go. Razor Sharp says it is going to cost the taxpayers $10 million. Wow. $10 million, guys. They just pissed away $10 million because the Virginia Supreme Court has no balls. Has no balls. It was a Democrat justice that wrote the decision. Wait, it was a Democrat that wrote the opinion or the dissent? I'm confused on that one. Trumpet, Uniparty. Good to see you, Trumpet. Uniparty, spot on. Spot on. They're all the same. They're all the same. And the craziest part is they probably are okay with the campaign funds because all of that goes to their cronies. All of that money, the campaign money is all going to political consultants and people that are making TV ads and, ad buys and all that stuff. It's all their friends that are making all that money. It's the taxpayer. It's the taxpayer and the donor, assuming that the money's not laundered through Act Blue, et cetera, and, these big corporations. That money piss it all away. But I'm talking about the guy, like I said earlier, the Republican in Virginia that's like, I don't want to lose my representation in this state and be a 10-1 state when we're 50-50, almost 50-50, 48-52. I don't want to lose all my representation. I'm going to put money into this. For the first time ever, I'm going to put money into a campaign. I'm going to donate. And so I'm going to give $100. And what am I going to do to put that $100 in? Well, I'm going to pull back a little bit this week. Maybe we won't have steak on Friday night, or maybe I won't take my kids fishing on Saturday, or something along those lines. Like, that's the injury, folks. That's what the Supreme Court allowed to happen because they're too chicken shit to overturn some precedent in a time, 1912, when the money in politics was nowhere near where it is now. I mean, we just had Willie Brown, that Willie Brown, downtown Willie Brown, Kamala Harris's Get Around. Yeah, that Willie Brown just a couple weeks ago was like, yeah, money in politics now is getting out of control. 1912, it wasn't the same, especially for a treasurer race. So, yeah, I think the Supreme Court shit the bed big time on this, and you will not change my mind. I've had people call me a Democrat over this. Like, okay, sure. People tell me I didn't read the decision. Bitch, I've read more of this case than almost anybody that commented on my post. You should have read the decision. I read the decision. I read both Tazewell decisions. I read the injunction decision. I listened to the whole arguments. I went back and did history on Scott v. James. I've read cases on Scott v. James. I've written 4 articles about this case. I read the NAACP and made the contrast with their arguments in the Supreme Court to stop the Supreme Court versus this. Like, don't tell me that I didn't read this decision, that I don't know what I'm talking about. I know what I'm talking. Well, you didn't go to law school. Piss off with that argument. You want to piss me off? Tell me that I can't talk about law because I didn't go to law school. You can fuck all the way off with that argument. And I'll just throw Ash at you, one of the better legal minds that I know, and she never went to law school. She just read the federal manual of the Federal Procedures Manual and defended herself and whooped ass. I don't ever want to hear that shit. You didn't go to law school. You can't comment on this. Please. But an ambulance chaser that went to law school for 3 years and had 3 credit hours on constitutional law somehow is an authoritative source on this. Fuck off with that. Okay, let's land that there. I got a cough. Okay, so how's everybody doing in the chat, guys? We're going to move on. We got a whole bunch of news stories, whole bunch of big news, man. Like the election thing is blowing up right now, big time. But before we move on, let's go ahead and hit a sponsor real quick, if you guys don't mind. Today's sponsor is Chicago Steak Company. Remember, I was just telling you, Dad might have to give up some steak. Hopefully it's not Chicago Steak Company. They're giving away 8 free steak burgers on every order with code 8burgers. Think about the last time you bought burgers at the grocery store. You stood there staring at a wall of plastic wrapped ground beef, trying to figure out which one isn't going to turn into a hockey puck on the grill. Maybe you grabbed the expensive organic pack, or maybe you went cheap. Either way, you got home, fired up the grill, and watched them shrink to half the size, dry up in the middle, falling apart all throughout the grates. Just crap meat, man. Chicago Steak Company figured out a better way. They make half-pound steak burgers from USDA prime beef, hand-formed from premium cuts, and they ship them to your door on dry ice. They'll hold together on the grill. They'll stay juicy, and they actually taste like steak. Here's the deal. Spend $189 or more on any steaks that you want and use code 8burgers, and they'll add 8 free steak burgers plus a bottle of steak seasoning, plus plus free shipping. That's $200 in free extras on top of whatever it is you order with 15,000 5-star reviews. These people know what they're doing. Just go to mychicagosteak.com/rumble and enter promo code 8burgers. That's the number 8, EIGHT, the letter, it's the word 8. 8 burgers. The link's in the description. Get them before they're gone. All right. Let's jump in. Damn, you're making me hungry. Gonna go smoke a bowl. I'm almost at the 30 days. I got 6 more days. I'm at 3 weeks now without smoking. It's been good. Your frame makes it look like you're a tiny guy behind a desk. I know, doesn't it? It's so weird. Should I make myself bigger? We'll make myself bigger. There we go. How's that? Is that better? Is that better? Now I'm a big guy behind a desk. It does actually look like it's my desk, especially if I bring the mic up to here. It's kind of cool. Kind of cool. I did that. That's completely and totally unintentional. All right, so let's let's just play this because I love to cover this guy because just watching him melt down and go full is epic. Marc Elias melting down over all the L's that he's been taking.
I've not heard you this angry in a long time. Just share with how this scrambles your workload.
Like, look, I mean, in the end, here's why I'm angry. In the end, Democrats are still going to take control of the House. Okay?
Yeah, right.
That's the good news, right?
Yeah, right.
In the end, I think Democrats still could win the Senate. In the end, like, politics will be politics. But the reason why I am so angry is because the Supreme Court of the United States chose to strike down a law that was passed in 1965 that Congress was in dialogue with the court, okay, over in the 1970s and 1980s. And for the last 40 years, we have lived under a set of principles that all players have accepted as a fair, level playing field. And then a group of white Louisianans decided to challenge a map. And the U.S. Supreme Court ordered the parties to argue a case that none of the parties wanted, which was whether the Section 2 of the Voting Rights Act was still in effect under the right test. And then the parties did it, and they chose to issue an opinion in the middle of May while primaries were going on. And then the U.S. Supreme Court thought, you know what? Sure, we let black voters wait 2 years and vote under illegal maps, but God forbid these white voters have to do the same in Louisiana. That would be a constitutional crisis. And against all of that backdrop, have we learned nothing? I mean, have we learned nothing? Has the broader legal community not learned anything? Other than the civil rights groups, have people not learned that when you do this to black voters, it turns out bad for democracy for everybody? So,
yeah, I learned that the civil rights groups are actually funding the white supremacists. I learned that SPLC. I'm sure we're going to find that out about more organizations. I'm sure we're going to find that out about more organizations. But Marc Elias is in full-blown meltdown mode right now. It is an absolutely glorious thing to watch as he is melting down. He's taking L's left and right. We're seeing we're seeing W's on our side everywhere. The Tennessee case where they redistricted there and redrew the maps is fantastic to watch. Blacks are going to lose their representation. They're going to lose. You were represented by a white Jew. Well, okay, a lot of people argue you can't be white and Jewish. I'm going to say it. A white Jewish dude. The guy was born in Tennessee. I don't think he's Israeli. I think he's just Jewish. I don't know. He looks pretty damn white to me. All right. An old Jewish dude. How's that? Steve Cohen, Representative Steve Cohen, Tennessee's 9th District, is most likely going to lose his seat now and give it up to Charlotte Bergman, a black woman from Tennessee. But please tell me more about the white supremacist law that was just passed in Tennessee. I wrote an article about that for the Gateway Pundit, and then everybody caught on after that. It was awesome to see that. Everybody started talking about that. I was sharing the shit out of that on Friday night. Every post I was watching these people melt down. Blacks lost their, and they were being specific, lost their representative. We know they're destroying black representatives, not representation, representatives. Okay. The assumption that, first and foremost, blacks somehow lost their right to vote is absurd. The assumption that blacks somehow all vote Democrat is also absurd. And the fact that blacks should be represented by an old Jewish white dude who eats KFC on the House floor is one of the greatest testaments to election fraud that I could ever imagine. Nobody wants Steve Cohen representing them. But again, I think it's all coming out. Did you guys see Susan Wiles, President Trump's chief of staff? Look, this is a very, very significant statement that she makes here. This is at the Barbara K. Olson Award, Women of Valor, the Independent Women's Forum, March 7th, I believe. Barbara K. Olson, she was the founder of the Independent Women's Forum. She died in 9/11 at the Pentagon. She died in the whatever it was at the Pentagon on 9/11. But here's Susan Wiles, rare public appearance, speaking appearance. And by the way, God bless, keep her in your prayers. She is suffering from early stages of breast cancer. So keep her in your prayers, but check this out.
Leaving the White House, he called me and invited me to dinner, which I was not in the inner circle. I was just overwhelmed. I couldn't imagine why. I drove down to Mar-a-Lago, which I think he thought I live, 10 minutes from there, but it's really 4 hours. And we had a lovely dinner, and at the end of it, he wanted to know why he won Florida, but maybe struggled in some other states that I think we're going to find out he actually did win. But leaving the White House.
Again, I think we're going to find out he actually did win some of these states. That is about as good a foreshadowing as you could ever imagine right there. That is, look, and Razor Sharp says, Justice Arthur Kelsey wrote the majority opinion. Warner nominated him. Luis Lucas voted for him. He is a Democrat. Interesting. Good to know. I did not get too much into the politics of the justices themselves. I don't do that. I don't do that with judges. Obviously, I know the Supreme Court justices and their political tendencies, but to me, that's not concerning. The law is the law is the law. It should be nonpartisan. But thank you for that, Razor Sharp. Appreciate the rant as well. Appreciate that. Coming from Susie, this is big. This is huge. Okay, so you guys know I've been in the election space since 2020. Since November 4th, 2020, I shifted everything that I had inside of me towards investigating elections, reporting on elections, covering elections, everything. One of the things that I've heard from all of the networks that I've made friends with, all of the networks, almost all of them, I only a Sith deals in absolutes, almost all of them, is that President Trump is gatekept, meaning a lot of the grassroots information that's out there has to go through gates in order to get to him. And I'll just be honest with you. Susie Wiles has always been one of those gates. And it's not that she doesn't believe in the election. I can't say one way or the other what she believes, but she was always the person that was like, let's focus on other things. Okay. And a lot of people give her shit, and I think a lot of it might be rightfully earned. Okay. She should be scrutinized heavily. Okay. A lot of people are around President Trump right now that I don't personally think should be, but, and a lot of that is chief of staff. Very important person. Probably, well, besides President Trump himself, the most important person in the White House is the chief of staff. And so, I don't have much of an opinion on her one way or the other. I don't think you're ever going to have a chief of staff that everybody's like, oh, that's a wonderful chief of staff, right? They're always going to be doing some shady shit and whatever. But the fact that she's talking about elections now is huge. Like, I can't underscore that enough. That's huge. So, on that note, let's jump into another story here. This came out. I wrote this article on Saturday. No, not Saturday. Friday morning. Hat tip to Jennifer Asper for tipping me off on this. As elections investigations continue, could Wisconsin be next? Could we see some election movement in Wisconsin? Perhaps. There was an FBI interview, according to the Milwaukee Sentinel, Milwaukee Journal Sentinel. It says a report from the Milwaukee Journal Sentinel claims that an FBI agent has conducted an interview with, quote, a high-ranking state election official, end quote, recently. The Wisconsin Election Commission Deputy Administrator Robert Kehoe was the alleged official with whom the agent sat down. They said it was, the outlet says, quote, how nearly 180,000 Milwaukee residents voted in the 2020 presidential election could be at risk of becoming public if the FBI compels election officials to hand over voting data here in its pursuit to relitigate Trump's election loss in the key battleground states. The ballots at issue, are part of a swath of votes in liberal-leaning Dane and Milwaukee counties that Trump sought to throw out during a recount that he paid for of Wisconsin's 2020 presidential election when the COVID pandemic fueled a spike in absentee voting. It wasn't just a spike in absentee voting, it was a spike in indefinitely confined voting. And I do want to remind you of this. Well, actually, you know what? Let's go back. Hold on. Let me go find this. Video real quick, and let's just take a stroll down memory lane with this. Real Robert RN, who Real Robert on X, who shares like completely antiquated stories, but every once in a while they're pretty relevant and rehashes, right? They're rehashes. But check out this rehash from election night.
I think 168,000 votes. 138,000 was it, Tim?
Yeah,
138,000. You see the same. And see, look, this makes no sense. This is not even statistically possible where you have linear movement along voting like this. So you have a skyrocket. It should have been moving along.
The argument is these are votes that came in, and they all came in at once. But the thing that's the irony of it, every last one of them broke for Biden?
There was not a Trump vote in there. They all vote, and you do not have a place in any state. Maybe Dixville's Notch, where there were 5 voters at the first thing, and they all 5 voted for Biden. Maybe there, but not when you have something of 138,000. You don't all break that way, and it still shouldn't be linear because you have so many counters that are counting across the way that they're all tallying and reporting, and you don't bunch them in and report one thing. So that doesn't look right for the process. It certainly does not look right for the fact that there is no place of 138,000 where you don't have both candidates represented. I mean, even the bluest city, you're still going to have somebody voting for the other party. And so these two things, it would not be a tight race right now had this not occurred. And this looks like it occurred maybe 4:30 in the morning. This is about 6:30 in the morning.
6:23 a.m.
There you go.
4:30 in the morning. Vote spike. 138,000 votes in Wisconsin. Every single one of them for Joseph R. Robinette Biden. And so that brings me back to just a little rehash here. Damn, Claire. You have a flair for drama, delivering just the margin needed at 3 a.m. I bet you had those votes counted at midnight and just wanted to keep the whole world waiting, says Ryan Chu of the Elections Group. And she responds, I just wanted to wait and to say that I'd been awake for a full 24 hours, LOL. Now that was sent. Chu sent his message, his email at 4:07 a.m. Vogue responded at 4:17 a.m. Now, when you look at the video that we just played, he says about 4:30 because he's looking at the map. If you look here, he's looking at the bottom here and just kind of estimating that this occurred probably around 4:30. So let's put it all together. Around 4:30, 138,000 votes spike in, 4:17, 4:07. You have Ryan Chu saying you have a flair for the dramatic or whatever the case might be. I think we all know what happened. Wisconsin definitely needs to be looked at. Claire Woodall-Vogue had to turn around. She had to send somebody back to grab a missing USB stick, one that they forgot, and they left behind. And this was at 3 a.m. Sent him back to go grab that. So it's pretty interesting. Now, I do want to go back, and this was a Truth Social post that President Trump put out on January 2nd, 2024. Page 1, summary of election fraud in the 2020 presidential election in the swing states. I am pleased to share a report that is fully verified. Most of the information was gotten from government sources, tapes, and other public records, and compiled by the most highly qualified election experts in the country. These numbers are determinative and, in all cases, are hundreds of thousands of votes per swing state, more than I needed to win that state. If the Republican Senate does not step forward and address this atrocity, it will happen again and be virtually impossible for Republicans to win elections in the future. And this is the report. And since we're talking about Wisconsin, let's do a refresher. We'll go through this report over some more episodes and talk a little bit more about it. But let's go ahead and zoom in. Wisconsin called by 20,682 votes. The Wisconsin Supreme Court ruled drop boxes are illegal under Wisconsin law in a 4-3 decision issued July 2022. The WEC Commissioner, Megan Wolf, unilaterally declared that ballot drop boxes could be used to vote in the 2020 election. There was no commissioner vote to adopt that memo. Ahead of the November 2020 election, Wolf encouraged clerks to use, quote unquote, creative solutions to deploy drop boxes that she said could be, quote unquote, unstaffed. There were 528 drop boxes used in the general election and a total of 1.969 million absentee votes cast, including 1.34 million cast by mail and 653,000 in person. In a concurring opinion of the ruling finding the drop boxes to be unlawful, Justice Rebecca Bradley, by the way, that was eventually overturned because another rigged election seated another Democrat, and they overturned a 2022 law in 2024. It didn't even get to sit for 2 years, and they overturned it. But let's bitch about precedent from 1912 in Virginia, right? Justice Rebecca Bradley writes, quote, if the right to vote is to have any meaning at all, elections must be conducted according to law. Throughout history, tyrants have claimed electoral victory via elections conducted in violations of governing law. In Wisconsin, election officials, quote, derive their just powers from the consent of the government. The right to vote presupposes the rule of law governs elections. If elections are conducted outside of the law, the people have not confronted their consent on the government. Such elections are unlawful and their results are illegitimate. Justice Bradley concluded that, quote, thousands of votes have been cast via this unlawful method, thereby directly harming the Wisconsin voters. This was a weird one. Like that case when they sued over the indefinitely confined, I'm not talking about the drop boxes, but the indefinitely confined, they ruled that COVID was not a justification for the indefinitely confined. But then they ruled that Trump had to go through and determine each person whether or not they were indefinitely confined and whether or not their vote should have been counted or not. And there was like 165,000 people or 240,000 people, and they couldn't go through and confirm that each and every single one of them was or was not. It would have, the manpower would have been insane. It would have taken months to complete. In the city of Milwaukee, nearly half of it, all of its votes were cast by mail, totaling 217,000. The city deployed 15 drop boxes, with election officials claiming they'd be under 24-hour surveillance. However, after the election, not a single municipality in the county produced a video surveillance of drop boxes in response to open records requests. Various responses included no records exist, no video requested time frame, no such records exist, and no security camera. The election integrity group True the Vote identified 107 ballot traffickers in Milwaukee between October 20th and November 3rd. By the way, they still stand by that. I know there's a lot of, discrediting because of the movie and all that, but their data, their work, and I've had discussions about this recently with the Georgia thing, who each made 20 or more visits to the Dropbox. Each trafficker made an average of 26 visits. I want to jump down here to the indefinitely confined. In 2020, there was a surge of indefinitely confined, resulting in 220,000 votes cast from individuals who were exempted from showing voter ID. This surge of suspect votes was due to Democrat election clerks giving advice that was deemed illegal after the election. It wasn't even after the election. It was deemed illegal after they made it. They took it down, but by then the damage had already been done, and people were already making the claim that they were indefinitely confined because of COVID. Not because they had COVID, just because of COVID. Instructing voters to identify themselves as disabled during the pandemic to avoid the voter ID law. Indefinitely confine voters who are supposed to be physically unable to go to the polls. Increased by an astounding 393% in Dane County from 2016 to 2020, 492% in Racine County, and 281% in Milwaukee County, 287% in the state overall. There were just 56,900 indefinitely confined in 2016, 70,000 in 2019, 220,000 in 2020. And then it talks about Scott McDonald. I mentioned him in my article. He's one of the clerks that said that you don't have to do the ID thing. What else we got? We'll probably go through this in more on another episode. I don't want to rehash this all right here because the election thing is going to be coming in full swing, and so we need to hit the elections hard. There is one last thing I do want to that I want to talk about here, but before we do that, I want to hit one final sponsor, and then we'll talk about that last little deal here. So let's go ahead and talk about our friends over at Rumble. How much control do you guys actually have over your money right now? Technology has changed everything. And now it's changing how your money works. Crypto started as a niche, but now it's going mainstream. Faster payments, more control, fewer middlemen. It's not hype, it's just where things are going. And getting started today is easier than you think. That's where Rumble Wallet comes in. With Rumble Wallet, you can buy Bitcoin, you can hold dollar-backed stable coins, you can even own digital gold backed by real gold, all in one place. Setup is simple. It connects with MoonPay. So you can use your debit card, your credit cards, your bank accounts, and you can be up and running in minutes. It's not about the amount, it's about getting in early and understanding what's coming next. Once you've set up, you can even tip your favorite Rumble creators like myself directly. So do this now. Scan the QR code or click the link in the description and download Rumble Wallet. From there, you can set up your wallet. You can tap buy and boom, you're in the game. You can take control of your money. Get started with Rumble Wallet today. All right. And thank you to Rumble Wallet. Guys, please smash the thumbs up if you have not done so yet. Got 232 people watching. That's good for a Sunday night on an impromptu live stream. Love seeing that. Thank you guys all so much. Smash that thumbs up. And the final story here in the Pitts v. U.S., the Fulton County case, the judge says the show must go on. They were denied. They were trying to claw back all their evidence. They didn't want to have the FBI going through and doing their due diligence and doing an investigation onto this, and let's go. That's a huge deal. Now, one of the arguments that they made in there, and again, last week we saw two big things out of Fulton County. We saw the DOJ subpoenas. We covered that. Not DOJ subpoenas, grand jury subpoenas. Much more difficult to quash than a DOJ, an administrative or judicial subpoena. So this subpoena is calling for all of the information on the poll workers, the election workers, the volunteers, happy faces, ACLU clerks, anybody involved, elections group, big one. Absolute huge one right there. Elections group, all of the people. Why? It's time to start laying out the players. It's time to start seeing who's going to roll over and say, hey, I had questions. I wanted to bring them forward. I was silenced. I was suppressed. Who knows? But again, those subpoenas are going to be very difficult to quash. They've already, Norm Eisen, Abbe Lowell, have already filed a motion to quash. I don't think it's going to stand up. I think there's going to be some modifications. They're going to narrow the scope of the subpoena. But I think ultimately they're going to be able to get these people subpoenaed. They're going to be able to get these people, make contact with these people. Hopefully some of them become whistleblowers. Hopefully some of them see the writing on the wall, that the walls are closing in, and they decide to come forward and speak. Hopefully, we'll see. I know there's a lot of good people in elections. They're not all bad. In fact, their majority, overwhelming, astronomical majority, are not bad. It only takes a handful in each jurisdiction. So then also with the Pitts thing, man, they make the argument all the time that, the statute of limitations, right? The statute of limitations has expired. But any effort, so perhaps when they continue to fight, and I don't know if this would hold up or not, but we always talk about, right, the last commission of the conspiracy, furtherance of the conspiracy. if they are going to charge us as a RICO case. The last furtherance of that conspiracy resets the statute of limitations back to that day. So, think of this, like, even if there isn't some outward, furtherance, when they fight against Garland Favorito for the ballots, for disclosure, for transparency, for accountability, is that a furtherance of it? When they went after President Trump in the Fani Willis case, was that a furtherance of it? When they went up to D.C. and met with Joe Biden, when Nathan Wade was up in D.C. meeting with people up in the White House, was that a furtherance of it? The statute of limitations thing is a joke. I think that they see the writing on the wall. They're absolutely horrified. They're terrified of what's coming down. And I love it, man. I'm here for it. So I'm going to raid you guys on over to BB here on the narrative. Who's he got on? Let's see. And I'll leave the chat open. So if you guys want to opt out, you can opt out. I'll leave the chat open. Oh, it's Ash. So we'll go ahead and raid you over there. I'll leave the chat open for you guys. So if you want to stick around, you just opt out of the raid and stick around. You guys can chat, do whatever. I'll leave it open for probably like an hour. But again, thank you guys all so much for tuning in. I know a lot of you guys prayed for my family this weekend with everything that was going on. So thank you guys from the bottom of my heart. Thank you so much for that. I deeply appreciate it. We will be back to our normal schedule. Wife and I are going to do date night on Friday. I'll be back at the weekend review on Saturday. Everything will be back to normal, barring some crazy emergency. It should be. Again, Badlands Daily, my social media on X. Check out my sponsors down below. We've got text CannCon to 35052 if you're interested in diversifying your portfolio with gold and silver. Love those things. I'll see you guys later, man. Thank you guys all so much for tuning in on a late Sunday night. Stay frosty. God bless each and every one of you. Make the deep state motherfuckers pay for this.
Open your eyes to a new world, which never knew existed.